Good afternoon, Boomers. Brian Tong here from Boomerlife.net. Today is January 12th, 2022. Can you believe it? Today I'm going to be talking about keeping your financial assets secure. What you need to know: if you don't protect your assets, which you've worked long and hard to accumulate, they could be lost very quickly. Why you need protection from lawsuits. You may think doctors, corporate executives, and those in other litigation-prone professions are the only ones who need to worry about protecting their assets. Not so. There are many circumstances in which your assets can be attached or garnished, including if you file for bankruptcy, get a divorce, or on the losing side of a civil lawsuit. Most people don't consider these circumstances until they occur. If your teenage child is on the wrongful end of a motor vehicle accident, for instance, it could result in the damaging party going after your assets. And that's especially if you're a teenager. You buy a car for your teenager and put your name on the title. Don't ever do that. Put their name on the title. Even if you have to co-sign for the loan, don't put their name on the title. Don't put your name on the title. Or picture this scenario. You hear a knock at the door one night. You find an elderly couple looking for your next door neighbor. You inform the couple that they live next door. When they thank you and walk away across your lawn to go to your next door neighbors, they get halfway across and the man steps into a hole that your dog dug and breaks his hip, the one he just had replaced. The next call you could get could be from a lawyer trying to find out your financial worth and what type of insurance you carry. It doesn't matter that the couple should have stayed on the sidewalk or at least taken care to avoid such an accident. In the end, your home, your dog, and a hole in your yard makes it your fault. So, what about protection caps for IRAs? Contributions and earnings in your traditional and Roth IRAs have an inflation adjusted protection cap of $1 million against bankruptcy proceedings. The bankruptcy court has the discretion to increase this cap in the interest of justice. In addition, amounts rolled over from qualified plans such as 403B or 457 plans have unlimited protection. However, this protection only applies to bankruptcy, not to judgments awarded in other courts. In such cases, state law must be consulted to determine whether any protection exists and to what degree. Many U.S. laws protect assets in the event of lawsuits, bankruptcies, and collection agency action. Purchasing asset protection is often cheaper than leaving yourself exposed to the worst case scenario. What about qualified retirement plans? Assets in an employer-sponsored plan have unlimited protection from bankruptcy, regardless of whether or not the plan is subject to ERISA. This includes SEP IRAs, simple IRAs, defined benefit and defined contribution plans, 403, 457, or governmental or church plans under the IRS Service Code Section 414. Amounts in your SEP IRA from regular IRA contributions are subject to a $1 million limitation. ERISA plans are also protected in other cases except under qualified domestic relations orders, where assets can be awarded to your former spouse or other alternate payees and tax levies from the IRS. For this purpose, a qualified plan is not considered an ERISA plan if it covers only the business owner. The protection for owner-only plans is determined by state law. What about Homestead? The amount of protection you have for your home varies widely from state to state. Some states offer unlimited protection, others offer limited protection, and a few states provide no protection at all. Be sure you know what your state's protections are. In Florida, the homestead exemption is $50,000 for purposes of calculating taxes, but homesteads are also protected against collection and cannot be forced to be sold in order to collect on a judgment. If you have a judgment against you only and your spouse is on the deed, no sale can be forced ever. Annuities and life insurance. Like protection of homesteads, the level of protection applied to annuities and life insurance is determined by state law. Some protect the cash surrender value of life insurance policies and the proceeds of annuity contracts from attachment, garnishment, or legal process in favor of creditors. Others protect only the beneficiary's interest to the extent reasonably necessary for support. There's also states that do not provide any protection. How to keep your assets safe. Although asset protection may have had a tainted past, legitimate strategies are available. Creating as many obstacles as possible for potential creditors to pass before they can get to your property could encourage them to make favorable settlements instead of getting involved in long and expensive litigation. Asset protection trusts are another topic. For years, wealthy individuals have used offshore trusts in locations like the Cook Islands and Nevis to protect assets from creditors. But these trusts can be expensive to establish and maintain. Now, a number of states, including Alaska, Delaware, Rhode Island, Nevada, and South Dakota, allow asset protection trusts, and you don't even need to be a resident of the state to buy into one. Asset protection trusts offer a way to transfer a portion of your assets into a trust run by an independent trustee. The trust assets will be out of the reach of most creditors, and you can receive occasional distributions. They may even allow you to shield the assets for your children. Requirements are that it must be irrevocable. The trustee must be an individual located in the state or a bank or trust company licensed in that state. It must only allow distributions at the trustee's discretion. It must have a spendthrift clause. Some or all of the trust assets must be located in the trust state, and the trust documents and administration must be in that state. If you're considering one of these, be sure to work with a lawyer who's experienced in the field. Many individuals have run afoul of tax laws because their trusts did not satisfy regulatory requirements. Accounts receivable financing. If you own a business, you could borrow against its receivables and put the money into a non-business account. This would make the debt-encumbered asset less attractive to your creditors and make otherwise accessible assets unreachable. Stripped out equity. One option for protecting your assets is to pull the equity out of them and put that cash into assets that your state protects. Suppose, for example, that you own an apartment building and are concerned about a potential lawsuit. If you took out a loan against the building's equity, you could place the funds in a protected asset such as an annuity, if annuities are sheltered against judgments in your state. Family limited partnerships. Assets transferred into family limited partnerships are exchanged for shares in the partnership. Because the family limited partnership owns the assets, they are protected from creditors under the Uniform Partnership Act. However, if you control the family limited partnership and thus the assets, there's no market for the shares you receive, so the value is significantly less than the value of assets exchanged. So what are some other ways to protect your assets? There are some inexpensive, simple ways to protect assets that anyone can implement. You can transfer assets to your spouse's name. However, if you divorce, the end result could be different from what you intended. Put more money into your employer's sponsored retirement plan because it might have unlimited protection. Buy an excess or umbrella policy that protects you from personal injury claims above the standard coverage offered by your home and auto policies. Make the most of your state's laws regarding homestead, annuities, and life insurance. Paying down your mortgage, for example, could protect cash that is otherwise vulnerable. Don't mix business assets with personal assets. That way, if your company runs into a problem, your personal assets may not be at risk and vice versa. The bottom line, you may have seen self-proclaimed asset protection experts advise their seminars or easy-to-use kits on TV or the internet. Perform extensive research, including checking with the Better Business Bureau, before deciding to use any of these services. And before you take any of these steps discussed in this article, meet with an attorney who's familiar with the laws of your state and is an expert in the asset protection field. Most important, don't wait until there's a judgment against you. By then, it may be too late, and the courts could declare that you made a fraudulent transfer to get out of meeting your obligations. Put your money to work. Managing your money effectively starts with careful planning. That's all for today, Boomers. I hope you got something valuable out of that. Join my site, myboomerlife.net, and read my blogs on a regular basis. Have a great day, and I'll see you on the flip. Brian Tong, Boomer Life, out.